There you have it, folks. The jury has the case in the Willis trial out of Michigan. This is Jeffrey Willis. He's accused in this instant proceeding of killing a mother named Rebecca Bletch, who was out jogging. He also faces charges in a couple of other cases, and prosecutors were able to bring bits and pieces of evidence from those other cases into the Bletch homicide trial. Those other cases are the murder of a gas station attendant and also the abduction of a 16-year-old. The state was trying to say that there was a common plan or scheme, and some of the evidence discovered while investigating one case ultimately led to some probative relevance in the Bletch case. Now, we heard in the defense's closing argument just within the last hour or so that the defense is still pushing this theory very, very hard that a cousin of the defendant named Kevin Bloom is the person who the defense thinks is really responsible. And I think that the defense did a great job of summarizing those points. Some very, very interesting discussions coming out of the defense here. Ken Belkin, LawNewz trial analyst, is here to go over just a couple of them with me. So Ken, I just want to throw these ideas past you here because you're licensed in one state, I'm licensed in other states, and so sometimes we get into these debates about the differences of how different states do things. But before I get into that, just a core argument from the defense here that the cousin had ultimately done the following: had kept photos of the victim on his cell phone, knew the victim, found out where the victim lived, destroyed evidence, knew about the gun, the serial number, and even the caliber, was obsessed with the victim, and in an interrogation called the victim nice, beautiful, attractive, and pretty. And so then the defense made this interest that, well, since the victim knew the cousin, that if the cousin was the one who really was on this murderous escapade, that if he pulled up alongside of her or tried to get her attention, since she knew him, maybe she would let her guard down for a split moment. The defense also tried to say that it's the cousin who's the expert marks person, and that would make the delivery of the shots that much more important because she was shot from some distance, yet she was struck in such a way by the bullets that would suggest, at least in the defense's theory, that there was an expert marks person at the trigger. There's talk about pornography along with the victim's pictures. So I think the defense, in a very quick, rapid-fire succession, really tried to seal its claim up that the cousin is really the responsible one. Do you think that's good defense work? Do you think the jury might buy it?
I mean, I think, look, juries love the third-party liability defense. Look, it's not my guy, he's wrongfully accused, it's this other guy. The juries really love having that Perry Mason moment. You know, it's tough to convict someone. It weighs on you heavily. Even, you know, not being just as an attorney on the case, but being on the jury where you actually have to convict, it weighs heavily on these people. And I think in some cases they look for a reason not to convict. I don't necessarily think they're looking for a reason not to convict in this case, but it's a good attempt by the defense.
Well, you know, you've also got the defendant who has his own photo stash on his own computer.
He's got a file that says VIX.
Yeah, in other words, victims, VICS. Yeah. And you know, so there's other evidence that would tie this particular defendant into this case. Certainly there was probable cause for an arrest.
He's a really creepy guy. And when he took I'm surprised he took the stand, quite frankly, but I guess they needed to get him up there to introduce this third party evidence into the proceeding.
Yeah, and you know, to try to you know, point the finger back at the cousin here, you know, I think some people on this jury might be scratching their head saying, look, these two are related. They've sort of implicated one another in a matter of crimes where they both involved in these crimes. Because we know that the cousin, and I don't recall exactly how much of this the jury got into, but we know the cousin said he was involved in the Jessica Herringer murder. Now that's the gas station attendant.
Yeah.
So if he's playing a role in that case, could they both theoretically have played a role in the Rebecca Bletch case?
I mean, personally, I think the truth is somewhere, you know, the prosecution saying, no, it's him. And he's saying, no, it's my cousin. I think the truth is probably somewhere in the middle, and that they were probably,
or at least it's arguable that it's somewhere in the middle. Yeah.
I mean, look, if he played a part in one murder, you know, chances are he played a part in the second one.
This may be one of these things where there are a lot of facts that are yet open to interpretation, but the jury just got the case moments ago. One more thing I want to talk to you about, Ken, because this sort of made the hair on the back of my head stand up. the state's rebuttal here.
Well, I'm not going to have that problem with the hair on my head, but
whatever. So the state's rebuttal. The prosecutor said, I've been practicing 18 years. It bothers me when people say I wouldn't dismiss charges against an innocent man. I took an oath of office, promised to uphold the Constitution. In my career, I've never prosecuted or convicted an innocent person. If I had evidence Willis wasn't guilty, I'd present it. He goes on to say Willis is guilty, find him guilty, find premeditation. The evidence supports it. Does anything about that rebuttal closing argument bother you?
I mean, look, I'm fine with just about everything except, you and I were discussing off camera a few minutes ago, the fact that he referenced his experience. That to me is a little bit bordering on the lines of impermissible because as we discussed, the jury might be like, well, this guy, he's been around the block, he's got a lot of experience, maybe we should lend more credence to what his side is saying. On the other hand, the judge is going to instruct the jury, as he does at the beginning of the trial, that opening arguments, closing arguments, they are not evidence. They are just attorneys arguing. You can take what you want from them and believe it, and you can discard what you choose not to believe. You can discard all of it if you want, or you can believe all of it. And the judge usually gives that instruction, and I'm sure the judge is giving the instruction in this case.
Exactly. Now, so here's what concerns me about it. I know some jurisdictions handle this a little bit differently, but the fear in many jurisdictions, including one of the ones where I'm licensed, is that a statement like that from a prosecutor could lend to the outcome or could result in the outcome that a jury would convict saying, oh, as you said, this guy's got a lot of experience. He must know something extra that suggests that this guy is guilty, or we should just roll over and go with what the prosecutor says because he's seen more of these cases than we are. And so then it puts the jury in the position of convicting not on the evidence, but off of the prosecutor saying, hey, look, I got this all buttoned up and squared away. Just trust me, go with me.
I think the judge's curative instruction in this case where he lets them know, closing argument, not evidence, just attorney argument, and you do not have to believe it. I think that sort of cures that and allays that fear.
I know some appeals courts that would look at this and very harshly chastise the prosecutor for it. Some would be inclined to flip the case if there was a conviction and say, no, new trial. Make sure you convict the guy on the evidence and the logical inferences from the evidence. The prosecutor's experience has nothing to do with either the evidence or inferences that can be drawn from the evidence.
Look, that's true.
That might be enough in some jurisdictions.
But the prosecutor's experience is not being offered into evidence. It's not like the prosecutor is taking the stand and he's testifying to his lengthy record of service in the district attorney's office. It's just an argument. It's just something being put forth in the closing argument. I think in New York, I think it would be totally permissible. I would object nonetheless.
Well, and in this case, we didn't have an objection, so I guess the issue is lost at this point.
They've waived it.
The standard in at least one of the jurisdictions where I'm licensed is you have to object in a timely manner or in closing arguments shortly thereafter. Now, whether there's some objection going on after the jury goes to deliberate, I'm not quite sure. But, that might be enough in some jurisdictions because some jurisdictions give a longer time leeway for an objection to a closing, because more is allowed in closing than in evidence and whatnot. So, look, that did bother me, and it could lend a jury to say, rather than struggle about this case, the prosecutor says there's enough here, let's just go with him because he's been around the block a time or two, and that would bother me.
But look, the defense attorney's been around the block a time or two as well. There's nothing stopping him from making that argument. But with respect to objections, you're absolutely right. I go by the old rule, you either use it or you lose it.
And my rule would be to use it more frequently than lose it, because when you lose it, you lose it.
Well, that's a good point. You don't want to waive rightful, proper objections. But at the same time, it's been pretty well documented that juries, when one side objects a lot, the jury gets upset with them. They get mad. They say, well, what are you trying to stop me from hearing? I want to hear what this guy has to say. And they sort of look askance at the side that's doing too much objecting. And I've actually seen it. It happened to me in a case in the Bronx a few years ago. And the district attorney just kept objecting. And it was just insane. It was like, God, just stop. Even the judge was like, you're killing me.
I just have a new idea, folks. I am going to object to what Ken Belkin says here on Law News. This would be the best thing.
LawNewz objections.
LawNewz objections to, I object to that pocket square. So, look.
Well, you should have made that objection in a more timely manner. I've been here for a while,
I've
so
waived
I think you
it.
waived it.
I've waived it. Okay, folks. Well, I think the Toledo case is back in session in Florida. We want to switch over to that. We're also continuing to monitor the situation in the Adam Matos case, also in Florida. That case still in the midst of jury selection. In the meantime, let's go back to Toledo.
In relationship with your cousin Lewis?
Yes, we are.
All right, and is there other family that came also to support him today?
Yes, my daughters.
Judge, I don't have any other questions of Ms.
Anything
Gonzalez.
from the state?
No, sir. Your Honor, we have the person.
Okay. Please remain seated.
So, folks, as the case usually is, as soon as we get back into the trial, the judge should silence. So here's where we are in the Toledo case. The defendant was convicted late last Friday. The conviction came down shortly after 5 p.m. The defendant now deciding, or rather facing the jury to see whether or not he'll be sent off to death row or whether or not this will be a life in prison sentence. Now, some of the so-called mitigation evidence, now this is evidence that would suggest the defendant shouldn't be executed, provided today, suggested the defendant was involved in a car accident and has some brain damage as the result of it. And the defense put up a medical expert to ultimately say, hey, look, this guy has problems with impulse control. He has other problems with his faculties that may have resulted in him snapping. Now, this evidence ties directly in to his statement to his neighbor that the jury apparently believed, where he said, quote, I snapped on the way back from ditching evidence. And Ken, I've been pointing this out a couple of times here on LawNewz. We get into so much of this mental evidence, if we can call it that, evidence of the defendant's mental capacity, faculties, whether there's brain damage, whatnot, because we've got appellate court standards that say that if someone is mentally impaired, they can't be executed.
And they can't form the requisite intent.
Yes.
You know.
So we have that playing into this. And I think it's a strong percentage of the reason why we see so many arguments in these death penalty cases surrounding what's going on in the defendant's head, literally, with the connections. How does he think? How does he process information? Because the attorneys are worried about trying to find a way to meet that appellate standard.
Yeah, look, I mean, if someone has a particularly low IQ, they would be considered by the psychological community to be, impaired or quote unquote retarded. You don't want to execute them. It's not fair to execute people of such low capacity. Look, they did a terrible thing. They should be punished, of course, for their actions. But to execute them, as a society, we've determined that that is not a civil way to handle these people.
I mean, do you think that such an argument would fit in this case? Because we've got a defendant who's putting all these experts up saying, okay, well, there's something going on there, according to these experts, the mitigation experts, in other words, saying that he's got brain functioning issues. But on the flip side, he's up, he's going to school. This is not somebody who's, had some kind of lifelong commitment or lifelong diagnosis that really impacted his life in a measurable way up to this point. So is this just an attempt at a Hail Mary pass, hoping that it's going to work? Or is this something that a jury might bite onto?
I think this is a bit of a Hail Mary. This is a vicious man. He is accused of doing a very vicious thing. And at some point, he's going to have to pay the price for these crimes. Personally, I think they should avoid giving him the death penalty, and they should let this guy rot in prison.
And
Death
what's your
penalty's
basis
too
for
easy.
that? Just because he has
no
said that he
legal
wants...
basis, it's just too easy. He wants it. We don't give you what you want. You committed a triple homicide. That's my opinion, for what it's worth.
That's shockingly harsh coming from a defense attorney.
Look,
punish the guy in the way that he doesn't want to be punished. I mean,
I have certain standards when it comes to my defense work, and crimes against children where the person is guilty of them, I'm not so into.
Well, I can understand that. Look, bottom line is we're at this stage in the case. We've had these mitigation experts on the stand. I was relatively certain going into this case that this was probably going to result not only in a conviction but a death penalty sentence. I'm wondering if the jury might bite onto this discussion from some of the experts that he actually had brain damage related to a vehicle accident that affected his frontal lobe decision-making centers. That might be enough. I don't know. It's a shot in the dark, but it might be. It's interesting.
I mean, look, they're gonna actually argue that this guy is effectively lobotomized from a car accident. He doesn't seem to be lobotomized. He doesn't seem to be lacking in frontal lobe capacity. You saw him in the interrogation. You saw him in court. This guy knows what's going on. He was a vicious member of a vicious gang, and he's committed horrible things.
Well, it looks like trial is resuming, so let's go back to the Luis Toledo case in Florida.
Okay, you may proceed.
So, Adrian, did you say N? This will be marked as Exhibit N. Do you see this document?
Yes, I know.
You saw this earlier when you were here?
Yes, sir.
Right, and it's, what is it, a blown-up photograph?
Yes, of our family.
Right. Do you recognize the people depicted in the photo?
I do.
And do you see Mr. Toledo?
He's the first one on the left.
And these are other family members?
Yes.
All right, that's when he was a young boy, maybe 8 or 9 years
He was
old.
8. Mm-hmm.
All right. It's my understanding Mr. Toledo has elected not to have this introduced as evidence, so it will not be evidence, and the jury will not see it, but we will keep it for purposes of the record. Is this the only one?
Yes, sir.
Okay, anything else?
Can we just get his statement on the record that he does not? I know that you made the statement, the attorneys have made the statement, but I think it would be great for record purposes if Mr. Toledo.
Okay, well, I think we have it on, he nodded yes. I'll just put that on the record, but let me hear it from your mouth. You don't want the picture to be viewed by the jury. Is that correct, Mr. Toledo? Correct, okay, so that's satisfied. All right, thank you, ma'am. You may step down. All right, and is the state going to have any more rebuttal?
No, sir.
So we're done?
Yes, sir.
All right, this is what I'd like to do is, it's 4 o'clock. How much time do you think it would, you would need to do a closing argument? State?
An hour. And I don't think it would be that, maybe 45 minutes, Judge.
Defense?
I don't know if it'd be that long, Judge, but the problem is, we haven't, I think we need to do a conference over what they're going to be allowed to argue.
Yeah.
Mitigators and all that hasn't really been hashed out. I don't want to argue something that's lower than not even going to be admissible.
Okay.
Judge, if it's possible, I guess the big concern is the scheduling tomorrow, right?
Yeah.
Just come back in and close and send them out, is that the problem?
Well, here's the issue. Mr. Johnson has a Spencer hearing before Judge Maltz in the morning, and I would like to very much accommodate Judge Maltz Spencer hearing, given that it was already continued once as a result of this trial. So I was hoping to knock that off, knock the closing arguments tonight, and then have the jury deliberate tomorrow. The alternative is having the jury come in at, how long do you think your Spencer hearing might take?
Well, Judge, we're not going to do much of anything other than present some additional victim impact statements. I know the defense has got a number, at least one witness that they'll call. There's a couple of others that we're going to object to. I don't think Judge Maltz, but we'll allow them based on what I know they're going to testify to, but I don't know that for sure. So it's hard for me to say.
You think if we have the jury come in at 11:30, that would give you enough time for the Spencer hearing?
It's really almost impossible for me because it's out of my hands. It's the defense witnesses. We're not presenting any new witnesses in that case. I know that there is going to be 1 or 2 that will likely testify. There's a couple of others that we're going to object to. So if you held a gun to my head and asked, I know you're not doing that. That's a figure
Well, no,
of speech.
I'm not doing that.
But I think that's just a figure of speech, Judge. Maybe not a very good one. I would say that's a safe bet, but I'm
Okay.
often wrong about predicting times.
I don't want to rush you, but I do want to get done. But let's just spend the balance of the day to go over the charge conference. I'm going to send the jury home, have them here tomorrow at 11:30. And we'll just start with closings at 11:30 tomorrow. So, and
And Judge Maltz may want, if we're not done, may take a break for us to do closings and then come back.
that'll be fine.
Yeah.
You do the opposite. You could actually use the closing argument at 8:30 and finish instead of do this thing.
No, I don't want to do that. I'll just have the jury come back in. What we'll do is this, we'll be in recess for a few minutes. I'm going to go excuse the jurors, explain to them that there's a possibility of sequestration again to bring their clothing and where to park and all those things. And then we'll come back and do the charge conference. If you want to take him so he can use the restroom when I come back, it'll take me about 15 minutes to take care of that. And I'll see you.
We're going on camera.
So we just watched the end of the day in the Luis Toledo case out of Florida. This is the case we've been following for quite a number of weeks here on the Law News Network. A defendant who was convicted of 2 first-degree murder charges related to the deaths of his wife's children and of second-degree murder related to the death of his wife. Ken Belkin remains along with me here. We just watched the end of the death penalty hearing here. So closing arguments in the penalty phase will be tomorrow at 11:30 a.m. Towards the end of this, we're a little back and forth between the two cases there, but a couple of interesting things happened, the most critical of which, from my perspective, was that the defense tried to admit into evidence a photo of the defendant when he was an 8-year-old child with his family. And the defendant said, I don't want the jury to see it. And the judge went along with the defendant. So is this a case where the defendant wants one thing and the defense attorneys want another thing? And why might that be?
Well, look, as defense attorney, your client is really driving the ship. And he can steer it towards the rock by not listening to your advice, or he could steer it towards calmer waters. Well, as calm as they can be, given the circumstance that he's been convicted of a triple homicide. If he doesn't want evidence introduced, he has the right to tell his attorney not to do it, but really strategy is the purview of the attorney, and ultimate objective is the purview of the client. But, the judge went along with his request, and, we're moving along here. He seems to want to die.
Yeah, and the attorneys, of course, preserved that they wanted to put the photo into evidence to show this defendant in a younger and presumably purer state.
Yeah, well, they don't want him coming back and saying that they provided him with ineffective assistance of counsel.
Yes.
That's really what it comes down to.
Exactly. So it's on the record that the attorneys tried to do it. The defendant chose not to do it. That wrapped up. They're going to be back in at 11:30 in the morning. Now let's switch over to the Matos case that we're also continuing to follow. This is a case of the state of Florida against Adam Matos. He faces 4 first-degree murder charges, 4 possible death penalties related to the deaths of his ex-girlfriend with whom he had a child, her parents, and another man that the ex-girlfriend was seeing. It's a bit unclear as to whether or not they were officially boyfriend-girlfriend or not, but 4 deaths in Florida. Adam Matos is the defendant. Right now, the attorneys are going over challenges against jurors for cause. Now, this is trying to narrow down the jury pool after a pool has been selected from the big pool, where the attorneys are trying to go through saying this person gets eliminated for things such as clear bias or some clear reason why the person should be off the jury. This is getting interesting, so let's listen into that case.